Yeah, I'm not, we still.
Good morning. Today is August 17th, 2023. It's shortly after 9:30 a.m. There was a short delay in beginning this hearing as people joined this webinar. My name is Carl Cox. I'm a private attorney appointed by the Clackamas County Board of Commissioners as Land Use Hearings Officer with authority to conduct this hearing and make a determination in this matter. This matter is the file Z0036-23. It's an application for an emergency access road by the Portland Water Bureau. This application was approved by the county pursuant to a level 2 process, and that application approval has been appealed by Surface Nursery, Mr. Sean Narrison, who is present this morning. I have a few important things to state for the record before we begin. First, this is a quasi-judicial land use hearing, which means two important things for those participating in this hearing. First, all of the criteria that can be used in reaching a decision have been identified in the staff report. Testimony, arguments, and evidence must be directed towards the criteria identified in the staff report or other relevant criteria found in the comprehensive plan or other land use regulation that the person believes applies to the decision. Accordingly, please direct your testimony to a relevant approval criterion. Second, failure to raise an issue accompanied by statements or evidence sufficient to afford the decision maker and the parties an opportunity to respond to the issue may preclude appeal to the Oregon Land Use Board of Appeals on that issue. Failure of the applicant to raise constitutional or other issues relating to proposed conditions of approval with sufficient specificity to allow the local government or its designee to respond to the issue precludes an action for damages in circuit court. Once final, this decision may be appealed to the Oregon Land Use Board of Appeals. Further, I will state for the record, I've not received any ex parte contact, meaning no one contacted me outside of these proceedings to try to persuade me concerning a fact or issue present in this matter. I did receive a link to the exhibits filed on the county's Excella website, and I had an opportunity to download and review all 61 exhibits. And there were actually more than 61 because there are multiples for certain exhibits. For example, 2A, B, C, D, E, and F. I also will state for the record, well, that I have not received any bias or I do not have any, I've considered issues of bias and conflict of interest and have determined that I do not have any bias or conflict of interest in this matter. The county is making a record of this hearing, and that record is available through the county. Prior to the end of the close of the hearing, I will make a statement concerning providing participants and members of the audience an opportunity to request that I leave the record open for an additional period. I'll make that clear at the end of the testimony today. This is an appeal of an approval, as I stated, of a county determination. As such, this hearing is de novo, meaning that I'm the trier of fact. We're starting over. I will receive all of the evidence and testimony and arguments concerning this, both the initial application and also evidence, arguments, testimony in support and opposed to that application by both the applicant and the appellant, Surface Nursery. I understand that there are quite a number of people present who are very interested in the outcome of this hearing. And as such, I intend to ask am asking that each of you limit your testimony to 2 to 3 minutes. If you are simply, if your intention here is to show support or opposition, please make that clear. But if you are, for example, a member or in support of for example, the Cottrell CPO, the planning organization, simply reference it, that you support the statements made by that organization or which organization that you support, and I'll make a note of that. And I also will consider the written testimony that was provided, and I'll reference that as well. The order of proceedings today will be, and I understand that Mr. Hultberg is asserting that the applicant should go first, but I'm going to ask that if the county has a presentation, does the county have a presentation? That the county begin by presenting the county staff report or PowerPoint presentation, followed by the applicant, Mr. Hultberg, followed by the appellant, Mr. Narrison. Then I will consider opportunities for rebuttal testimony. Okay. I'll ask that the county begin with that staff report.
In other public hearings, there has been a Zoom script read by staff to
right.
let people understand how to provide testimony. Would you like me to read that prior to presenting my staff report?
Yes, thank you.
So this public hearing is conducted virtually using the Zoom platform. Today, the panelists for today's hearing include the hearings officer, county staff, the applicant, and the appellant, who have both audio and video capability. Audience members who have joined the meeting will have their mics muted unless they wish to testify, in which case they will be called upon to do so by the county staff moderator. Audience members' video will not be turned on at any time. Today's hearing is being recorded as required by law, and the county will make every effort to post the recording on the county website later today. There is a designated time during the hearing when it will be open for testimony. The hearings officer will make it clear when this is. If you want to provide testimony, you will utilize the raise hand feature. Attendees on PC and iPad, you have a raise hand button on the Zoom bar, which is either at the top or the bottom of your screen, depending on your device. When the moderator switches you over to provide testimony, your screen will look different for a little while. Primarily, you will see all of the participants' cameras, not just the one who is speaking. Staff will call upon you when it is time for you to provide testimony. Be sure to provide your name and mailing address when you begin. Once you provide your testimony, your mic will be muted and your screen will be returned to normal. If the record is left open at the end of the hearing and you wish to submit additional written testimony, email written testimony to myself, Joy Fields. My email address is jfields@clackamas.us, or you can mail your written testimony to Clackamas County Planning and Zoning Division at 150 Beaver Creek Road, Oregon City, Oregon, 97045. The staff contact and email address is also available on the website where you found the Zoom link for today's hearing. Testimony must be received by 4 p.m. on the day the record closes. People who testify and provide their mailing address will receive a copy of the hearings officer written decision. If you do not wish to testify, but would like to receive the decision, you must provide your email or standard mailing address by emailing it to the staff contact for the application or by entering it in the Zoom chat function during the hearing. The last slide of the PowerPoint presentation has my email address and the mailing address for the Clackamas County Planning and Zoning Division. And so that will be another opportunity for you to jot down where to provide written testimony. With that, I will move over to my staff report.
Thank you.
So we are here today to consider Z0036-23 type 2 land use application for the emergency access road. And this is the appeal hearing. The proposal by the Portland Water Bureau was to construct an emergency access road to serve the proposed water filtration facility located in Multnomah County. The application considered by Clackamas County was for the emergency access road only, because that is the only part of the utility facility that is located in our planning jurisdiction in Clackamas County. The applicant characterizes the use as a utility facility necessary for public service, which is a potential use allowed in the exclusive farm use zone where the emergency access road is proposed. In the application material, the applicant provided that the emergency access road would have an all-weather gravel surface and would vary in width between 20 and 26 feet. The extra 6 feet would be widened around the proposed fire hydrants. That was a facet of the emergency access road requirement by the fire department that would serve the utility facility. It was noted that the emergency access road would also include fiber optic cable and a water supply line to serve the 2 fire hydrants. In addition to the emergency access road, the applicant proposed a temporary construction access road that was a width of 30 feet, and it was to provide construction for the utility facility located in Multnomah County, in addition to the construction of the emergency access road. Both the temporary and permanent easements were proposed to vary in width.
Ms. Field, I had just wanted to clarify that the proposal, I saw the maps of it, and it showed the proposed emergency access road generally following, yes, that blue line that you've dragged your cursor across. And then the construction access road that was discussed is that dogleg just off that bottom triangle, correct?
The temporary construction road included the dogleg here, in addition to additional width along the proposed emergency access.
Thank you for clarifying that. That is what I understood.
So the location of this is on the north side of Bluff Road. The emergency access road was proposed at the intersection of Bluff with 362nd and Southeast Proctor Road. The emergency access road was proposed to be between 2,600 and 2,650 feet long, going from the Multnomah County line down to Bluff Road. Again, that is only considering that portion of the emergency access road in Clackamas County. The site is located between farmland that is located to the west and a school, a solar field, and a residence located on the property to the east. Based on aerial images, it appears that the majority of the proposed emergency access road is currently a farm road or a driveway access. The zoning designation of the underlying land is exclusive farm use, or EFU. As noted in the application, it involves 3 separate tax parcels because of the location of the proposed emergency access road. And those 3 separate tax parcels are identified in blue here. And you'll see it on the north side of Bluff Road at that intersection. The applicant provided an aerial image that shows where the filtration facility is located in Multnomah County. They also provided information on wetlands and other zoning designations to the west of the filtration plant, as well as topography and additional farmland zoning to the east. And then they provided information on zoning around this potential access as well as this potential access. And they elected to choose the access in the application due to the topography, the limit to impact to wetlands, as well as the direct access that it provides. In the decision, this aerial image of the existing driveway was included. It shows the existing drive at that intersection that we're talking about, and you can see the dog leg, which correlates to the additional temporary construction road that would cross the corner of the property and enter Bluff Road approximately 300 feet to the west. In the staff report, I did not include this aerial image, but I wanted to include it here because it was discussed when staff reviewed 1002. Because the applicant proposed that the emergency access road that would follow the existing farm road would limit disturbance to the natural wooded areas located to the east of the project location, and thus would have limited impact to the natural features in the area. And that was discussed in the narrative, but there was no image in the staff report regarding that. So I wanted to clarify that. This is the site plan provided by the Portland Water Bureau. It shows the emergency access road from the intersection down here all the way up to the Multnomah County line. It includes that jog that goes around the trees and stays on the properties that were identified in blue in the tax map. A close-up of the site plan for the temporary construction roads shows the addition of space required for the temporary construction roads. In addition to the primary emergency access road, there is additional farmland that would be impacted by the temporary construction roads, including that dog leg. The tax map here is for Township 1, Range 4, Section 27, and it includes 2 of the 3 properties. You see the other property that is in the adjacent tax map. In reviewing this type 2 land use decision, staff reviewed the definitions in Section 202. And found that the utility facility was an institutional use and was subject to the 1000s development standards. Looking at the proposal and those standards in the 1000s, we spent time specifically addressing criteria in Section 1002, which is the protection of the natural features. Section 1003, which are hazards to safety, because the vicinity in that area of Clackamas County and Multnomah County does have landslide deposits. However, the proposed location for the emergency access road did not have any indication that there were steep slopes or landslide deposits. They are a factor in the alternative locations that the Portland Water Bureau considered, specifically the steep slopes to the east of the filtration plant. But in the site where the emergency access road is proposed, no hazards to safety were found. Additionally, there was no historic resources known to county staff or in our electronic records for historic resources in the emergency access road proposed location. Being an institutional use, it's subject to 1006, which addresses utilities, streetlights, water supply, sewage disposal, surface water management, and erosion control. Because it is not a structure that has any sewage that did not seem applicable to this application. However, it is in a groundwater limited area, and because of the fire hydrants, it is important to make sure that there is sufficient water capacity to serve those fire hydrants. The applicant provided evidence from the water providers of that area that would serve the fire hydrants that they have sufficient capacity for that fire flow. Additionally, surface water management, which is regulated or managed by the Transportation and Engineering Division of Clackamas County, indicated that the project was sufficient to address surface water management, and erosion control would be addressed during the construction of the emergency access road. Section 1007 was for roads and connectivity. Staff that specializes in the road standards, I reviewed the application and found that the use by the emergency access road was not anticipated to impact that intersection at Southeast Proctor and Bluff and the proposed emergency access road due to the limited number of trips. In the application, the applicant identified that it's estimated that there could be 20 trips a year for emergency access vehicles during emergencies. And that was not anticipated to cause an issue at that intersection. The transportation and engineering staff also reviewed the temporary construction roads and the traffic impact analysis that the applicant provided for the temporary construction roads, and found that there would need to be improvements at the access at approximately 300 feet to the west of the emergency access road that would be used for temporary construction if approved. There would be improvements needed to ensure that Bluff Road remained up to Clackamas standards, but all of that would be addressed through a development and engineering permit and could meet the conditions of section 1007 as conditioned in the land use approval. We also reviewed section 1009 for landscaping, and you'll find that in the staff report. One of the items that is unusual with this application is our zoning and development ordinance require that land use applications be signed by the property owners. And when the application was submitted and initially deemed complete, all of the property owners had signed the application form as required by our zoning development ordinance. However, on March 9th, Deborah Surface withdrew their signature, and Nathan and Brittany Burkholder revoked their signature on March 27th. In the letter dated May 24th, 2023, legal counsel for the applicant noted that the applicant has the power of eminent domain and was initiating the condemnation process. And therefore, the applicant postulated that they had the authority to apply for this land use application, and county council agreed that they could move forward with the application and we could move forward with our review. In section 401 of the zoning and development ordinance, it covers the uses that are allowed in the exclusive farm use zone. And a utility facility necessary for public service is identified as a use that is subject to the type 2 land use application. And the applicant provided that the filtration facility proposed in Multnomah County is a facility that is needed to continue providing reliable, safe drinking water to nearly 1 million people, and is needed to meet the federal requirements for water quality. With that, staff found that it was necessary for that utility facility. The applicant cited the Citizens Against LNG versus Coos County, which is a LUBA case from 2011. And they propose that the temporary construction activity is not a use in itself, but rather an accessory function that is necessary to construct the authorized use. Again, the application considered by the county was for the emergency access road only. And therefore, the construction of the emergency access road is a function of that authorized use. However, staff found that the construction of the temporary construction roads for the construction of the utility facility was an accessory transportation improvement under the Oregon administrative rules and must be evaluated under the standards for a utility facility necessary for public service. Because the temporary construction roads were not only to be used to construct the emergency access road, staff needed the applicant to identify how the temporary construction roads were necessary to serve the utility facility. And staff found that the utility facility necessary for public service may be established provided following the Oregon Administrative Rules 660-33-0130-16A. And the applicant provided information documenting that the proposed emergency access for the water filtration plant is locationally dependent. For direct access by emergency vehicles, the road could not be sited to the west because of the wetlands that would require a meandering, multiple turns, and indirect road access, and could not be located to the east of the filtration plant because of the steep topography that would not meet the slope required by the emergency access vehicles. In addition, to the east is also a farmland. And the exclusive farm use land through Clackamas County met the slope requirements, did not have any wetlands or significant natural features that needed to be avoided. And thus the emergency access road for the filtration plant was locationally dependent. The applicant did not provide evidence to indicate that the temporary construction roads were locationally dependent under that same Oregon administrative rule. And therefore, when staff reviewed the application, we separated out the emergency access road from the temporary construction roads. The land use approval for Z0036-23 was a conditional approval for the emergency access road only. The temporary construction road that was to be used for at least 5 years to construct the filtration plant that extended southwest across tax lot 200 was excluded from the approval. And therefore, the land use approval did not authorize or consider the emergency access road by filtration plant construction traffic. The emergency access road is for emergency access only in our land use approval. We received an appeal of our land use approval, and the appeal had several items. One was that the filtration facility could be located inside the urban growth boundary and thus avoid the impact to the exclusive farm use zone. Additionally, the appeal appealed the conditions of approval for Z0036-23. I apologize for that typo there. Because they failed to ensure the impacts from the emergency access road would not significantly change the accepted farm practices or the cost at Surface Nursery. Under that reason for appealing, they had 3 items. One was unrestricted access to the emergency access road. I would like to hear a little bit more about that from the applicant to see if that is unrestricted access for Surface Nursery employees, or if that is unrestricted access for the public. Impact to the farming from the construction of the emergency access road, Surface Nursery did not feel was adequately addressed. And the limit of emergency access road was not defined. And so that is what we received in the appeal. Do you have any questions at this time, or shall I put up the testimony contact information?
Just go ahead and put up your contact information. Your presentation was very clear. Thank you.
Okay.
I have a note that Carrie Richter is present in the audience, and can we have her promoted to a participant?
Yes, Sean, is Carrie Richter representing you?
Yeah, yes, she is.
Okay. I've moved her over.
Thank you. Okay. At this time, I'm going to provide an opportunity for the applicant to present evidence, testimony, and argument in support of the application.
Good morning again, Hearings Officer Cox. My name is Steve Holtberg. I'm with Radler White Parks in Alexander, and we are representing the applicant, the Portland Water Bureau, in this matter. My contact information is already in the record. With me this morning is David Peters. David is the engineering manager for the Bureau. We also have a room full of consultants, experts, project engineers, and city staff on hand to field any questions that either David and I can't answer. In terms of our presentation, David's going to provide a brief overview of the project, and then I will present our case. As the hearings officer is aware, the application materials are substantial. In this case, we are largely going to rely on our written materials rather than going through all of our written materials. With that in mind, I intend to keep our presentation very brief. I also understand that there are a number of people in the audience that would like to testify, so we'll do our best to keep our presentation pretty brief. And obviously, we're happy to discuss any issues with the hearings officer that we do not discuss in our presentation this morning. One thing that I would like to make clear before we move forward, because I think there was a lot of testimony on this issue, is that the Water Bureau no longer plans and is not challenging the condition restricting construction use of the emergency access road. To be clear, the construction window of 5 years that was mentioned before, the Bureau no longer plans to use that road for construction of the facility. Use of the emergency access road will be limited to the emergency use as we've described in our application. And with those remarks, I'm going to turn it over to David. I think David has—
One moment, while you're on the subject,
Of course.
let's talk about the Portland Water Bureau's understanding of how that will work with respect to access to the emergency access road by Surface Nursery, its employees and staff and members of the public. What is the intention here? It isn't clear.
David, I'm going to leave that question to you if you don't mind.
Okay, be happy to answer that. Hello, Hearings Officer Cox, Ms. Fields.
I appreciate the opportunity to be here today. In regards to the use of the emergency access road, so as we've discussed, emergency vehicles and things like that will be allowed. The intent is that access will be gated. It'll be a gate that will have access for emergency vehicles and things like that. And as that entrance currently is, it already has a gate on it. We'll be continuing to have similar access. We have been working with Surface Nursery to develop a road system that we can both share together. We recognize that's part of their farm there, and they use that road frequently for access for their employees and equipment. And our intent would be to work with them to find a common way that we can continue to allow them to do that. This will not be accessible to the public. So on both ends of the road, there will be gates off of Bluff Road at the south end, and also on the north end at our property. There won't be any public access on this road.
Okay.
Does that help clarify?
A little bit. So the current situation, there is a road there. There is a gate. Who has that gate? Who has the key to the gate?
So that's currently the gate to the solar facility that's located. That's the third property on the east side that we're coordinating with on that.
Thanks for clarifying that. So it's the solar facility has an access road that you intend to utilize for the PWB's access, emergency access. It's already there serving that solar facility, and it's gated and locked, and they're the ones with the key to the gate.
Currently, that's the case, yes.
Okay, I just wanted to make sure there wasn't a change in farming practices for the local farm use. Okay, but that's your understanding. It's not a shared easement or a shared gate?
Shared with Surface Nursery?
Yes.
Or is that? I don't know the answer to that question.
That's fine.
Surface Nursery would have to answer that.
I want to get a full picture of what we're talking about here. That's
the access road for the solar facility. That's why there's a jog in our road. We're primarily using that for the southern portion of the road, and then we jog over on the Surface Nursery side for the northern piece.
I saw that.
Yeah.
And is there a parallel road that Surface Nursery is currently using on where you jog over?
There is currently a farm road on their side of the property. Yes.
And would they continue to have access to that portion?
That is our intent. Yes.
That's your intent. Okay. So Surface Nursery staff, Surface Nursery customers, if you will, I understood it was like a U-pick blueberry farm perhaps, but would not be able to use the emergency gate on Bluff Road next to the school, but would be able to use the portion of road that crosses what is now their property.
Yes.
Okay. Did I state that fairly clearly? You said yes, very.
No, I was trying to get it straight in my mind. It's so.
Me too.
Once they're on the farm roads on Surface Nursery's property, they'll still have access to this farm road that's on their property.
All right. Thank you. Because I understood from the staff report and the submissions in the exhibits that Portland Water Bureau is looking at eminent domain to seize ownership, or perhaps just an easement across that property, but it's not your intention that it be only accessible to PWB.
Correct.
Okay, thank you for clarifying that. Please proceed, and I really appreciate the time you took to clarify those things for me.
No, that's why we're here today. So appreciate the questions.
Actually, while we're on this topic, which I view as central here, Ms. Fields, did you have a question for Mr. Peters? Because during your testimony, you were discussing this as well.
I had a question for Sean, making sure that I understood the item in their appeal form. Although it's not my case to consider their appeal, it is yours.
Same, sure.
So was there a question for me?
No, I'll get back to you when I have the appellant. I thought that Ms. Fields might have a clarifying question from Mr. Peters. Please proceed, Mr. Peters, and thank
Okay.
you. Harrison.
Thank you. So I just have a few slides, as Steve mentioned. I'll pull those up now and run through them quickly. Can you see that okay?
Yes, sir.
Okay, perfect. So here today, I'm just going to give a brief overview of the background for our facility, and then we'll move to Steve, who will give more of the legal arguments for what we're considering here today. So the Portland Water Bureau is we provide drinking water to nearly 1 million people in the Portland metropolitan area. Our primary supply is the Bull Run watershed, which has been providing water to the city of Portland metro area since 1895. And so we've been in this neighborhood with 3 large conduits running through. Okay, just a moment here.
It appears that David's having some technical difficulties. And David, you are now muted.
Yeah, I'm getting some technical support here. Apparently there's something in front of.
Is it music? Okay.
Okay, I'm sorry about that. Now I need to get my share back. Okay. Can you see the full screen? They were suggesting there might have been a box in front of the screen.
Yes, sir. And I see the blue line extending from Bull Run watershed through Gresham to the city of Portland. And I see indicated on the on that blue map, the filtration facility, the proposed siting.
That's correct. Yeah. So 3 large conduits bring that water into town. We bring in on average about 100 million gallons a day over the course of a year. And there's highs and lows to that. So it's not 100 million gallons every day. We serve City of Portland residents, but we also serve water to 19 wholesale customers throughout the metro area. Those customers include folks in this area that the filtration facility will be built, with the Pleasant Home Water District and the city of Sandy being a couple examples. The reason we're doing the filtration project is that in the drinking water quality requirements that the EPA has changed, and that meant we had to do more to treat for a microorganism called Cryptosporidium. And we were able to show in the first few years after the rule came out that we had very low incidence of Cryptosporidium. And we're able to get a variance from this rule to postpone having to do any more treatment. That changed in 2017 when the incidence of Cryptosporidium increased above levels that we could manage with our existing drinking water system. And that's when we had that variance revoked, and we had to work with the Oregon Health Authority to come up with a plan for providing treatment for that, for Cryptosporidium. We took that question to the Portland City Council, evaluated alternatives with them, and the Portland City Council chose to go with filtration as the option for treating for Cryptosporidium. That happened in 2018, late 2017. And at the end of 2017, we entered a bilateral compliance agreement with the Oregon Health Authority that had a planning, design, and construction schedule for that facility that requires us to have a filtration facility in place by September 30th of 2027. in the early stages of our planning, we went through an evaluation of alternative sites before we selected the site that we are currently working on. And the facility that we chose is a site that works well from a hydraulic standpoint for our drinking water system. We are a gravity-fed system, meaning that we have 2 dams up in the watershed. The water enters the pipe and flows downhill into the city of Portland without having to be pumped. With the site that's been selected here in East Multnomah County, we'll be able to continue that gravity flow component, which is a very sustainable approach for a drinking water system like ours to minimize our energy use. The site is also close to our existing pipe, those 3 existing conduits that we have coming into town, which allows us to reduce the amount of new pipe that we have to build to connect to those facilities. And it's a site that we've owned since 1975 and has a zoning in Multnomah County. It's a multiple use agricultural zone that has use by a community facility as a conditional use. So we have to meet conditional use criteria to be able to build there, but we have made a case to show that we will be able to do that. So this filtration facility is not located on EFU land, and with the 95 acres that we have, we have a site where we'll need to build about 40 to 50 acres of facilities. And so we'll have buffers around the facilities that will help screen us from neighbors in the area. The last piece, the connection to Clackamas County that we're here to talk about today, is the fact that we're on the Multnomah-Clackamas County line. So where we have to meet criteria for an emergency access, that has us looking to the south, crossing that county line into Clackamas County to get to Bluff Road. And we'll obviously be talking more about that in the next few slides. A little bit about the facility we're constructing. I mentioned the size will be 40 to 50 acres that will be composed of our campus. We'll be able to treat up to 135 million gallons per day at this facility, which will allow us to treat enough water on our peak days during the summer. We're using a conventional or granular media filtration facility. And as I mentioned, part of our plan is this proposed emergency access road. So the need for the emergency access road came from our review with the City of Gresham Fire Agency, doing a review on behalf of Rural Fire District 10. And their review of the fire code would suggest that for our facility, we need a secondary emergency access road. And that road needs to be, the primary entrance and the secondary entrance need to be separated by at least 1/2 of the diagonal lot distance. So we've gone through and we did an evaluation of our site and came up with a diagram that looks like this, where we looked at the diagonal distance, we looked at the 1/2 that distance, and we do have our primary entrance to the north. And so we are looking at where are areas that we could put the new secondary access. And
could you explain this again? I am no longer the math and science guy that I once was, and maybe a little unclear on this. You said would you explain how this worked again for the required minimum separation?
Yeah, so let me go back. So it said the 2 separate fire access roads are required and shall be separated by at least 1/2 of the diagonal lot distance. So the way we evaluated that is we looked at the diagonal lot distance, and we looked at the longest route here, which is the 3260 feet. And we took 1/2 of that. So that's 1,630 feet. And from the primary entrance, we just drew a circle around that and saw where that intersected on our site. So somewhere along here, along the boundaries of that line is where we would need to build the secondary access road.
Okay, and I saw in your supporting materials, I can't say the exact exhibit number, there were a lot, that you evaluated that stretch along Dodge Park Boulevard from your dotted line to the end of the property. And you also considered this small area over here to the, yes. And and your consultant rejected both sites. Do you have some
Right.
discussion of that?
So the reasons for that is, as you look along Dodge Park, these are really steep slopes and heavily treed. As we go to the east side, there's a private residence in an EFU property, but it also goes down a steep slope that is treed. And then as we look to the west, what we have is a sensitive environmental zone with the headwaters of Johnson Creek. And actually, Steve will get into more details about that evaluation and what it meant here in the next slide. But does that kind of answer the question? And we'll have more to add to that as we go.
Thank you, sir.
Okay. So I think that is all I had. I was going to let Steve take it away from here.
Great. Thank you, David. In terms of the hearing outline today, I do want to discuss in a bit more detail the alternatives analysis that is shown up on the screen there, address a few of the appeal issues, and then address what I think you referred to as the dog leg on tax lot 200.
I did, and I have just one quick question. Do you intend to submit the presentation, the PowerPoint that we just reviewed as an exhibit?
We will submit that, yes.
Thank you.
Despite the fair amount of public comments received, this is really a pretty straightforward application. As David mentioned, the emergency access road is required by fire department standards and is therefore both an integral and required component of the filtration facility. And as such, under the ZDO, the road is classified as a utility facility necessary for public service. And these types of uses have been allowed by statute since 1999. And it's largely a recognition that sometimes utility facilities have to go in a certain spot. And that is certainly the case here. And although utility facilities are allowed as permitted uses in the EFU and not as conditional uses, in order to establish a utility facility necessary for public service, you have to meet one of several factors. First and foremost, you have to demonstrate that reasonable alternatives have been considered and that the facility must be sited in an EFU zone based on one or more of the factors set out in the statute. And as our materials demonstrate, and as the decision confirms, the Bureau did consider reasonable alternatives to this site. David summarized those just briefly a moment ago. And the conclusion you have to reach is that based on the alternatives analysis and the factors set forth in the statute, which is 215, 275, the emergency access road here must be sited in an EFU zone. And that's where all the evidence leads, is that the only location for the road is located in an EFU zone. Again, as David mentioned, the need for the road stems from fire department code standards. And, based on these two exhibits and the one that David showed, there are very few areas that are available for an alternatives analysis, even to review. What that curved line again shows is the required minimum separation between the primary access on Carpenter Lane and the emergency access road. And
One moment. Mr. Narrison, would you please mute your mic? We're picking up some background off of your.
Okay, I was on mute. Can you hear me now?
Oh, it's somebody above you, holding
Okay.
a phone, I think, perhaps
Okay. I'll,
them drop or mute or,
okay.
okay, thank you. Excuse me, Mr. Holtberg, I just wanted to see if we could get them to mute.
Certainly.
Go ahead.
And, and again, so this separation requirement really constrains where we can place this access road. And given the separation requirement, the alternatives analysis was necessarily limited to really 3 areas along the short portion of the western border of the property, the eastern border of the property, and then the southern border of the property along the county line. And again, as David mentioned, areas to the east of the property are significantly constrained by slopes and seismic concerns. We had a supplemental analysis done, a geotechnical analysis done that considered access to the east, and that was rejected based on slope constraints as well as geologic and seismic hazards. There are really no effective ways to mitigate those issues with an access road to the east. And so both, our alternatives analysis and the supplementary geotech report demonstrate that rather conclusively. And as shown on the screen, they're forward left with the western access and the southern access. And the western access is not feasible for several factors, including excessive slope, indirect access, and impacts to state and federally regulated environmental areas. As you can see, the road is by no means direct, and any road in that area along the west would have to necessarily cross wetland areas. And anyone who's done wetlands work is aware that you have to do an alternatives analysis for wetland work. And if you can avoid it, you shouldn't fill the wetland. And so that largely leaves really only the southern boundary as an available option for an emergency access road. And as you can see on the screen, all of the property to the south is zoned EFU. And if your only option is between EFU properties, you don't even really have to do an alternatives analysis. Yet we did an alternatives analysis of these 2 locations. And the eastern route, which is the selected route, which joins the solar farm, was selected for several reasons. First, it avoids crossing Johnson Creek and the associated wetlands. It minimizes existing farming operations on that property. It avoids the county's river and stream conservation area. And again, it also avoids the need to obtain federal and state regulatory permits. Most importantly, the eastern route was selected here because it follows an existing farm road. That road is in existence. It is being used by the farm. It will be continued to be used by the farm. We are simply upgrading it to fire department standards to provide the secondary access to the facility. And for these reasons, our alternatives analysis demonstrates that that we considered reasonable alternatives, and that this is really the only reasonable alternative for this project. And before I move on to the appeal notice, do you have any questions, Hearings Officer Cox?
Yes, I just wanted to verify or have you state for the record whether or not the applicant is contesting any of the proposed conditions of approval by the county.
We will get to the condition number 1 in reference to what I think you called the dog leg across tax lot 200 further on in our presentation.
Okay, thank you.
But that is the only issue that we would like to raise. So when a county approves a utility facility for necessary public service, the statute requires that the county impose, quote, clear and objective conditions to mitigate and minimize impacts of the facility on farm practices and increases in farming costs, if there are any such indicated. The appeal notice takes issue with the fact that the county didn't impose conditions to minimize any farm impacts. The reason the county didn't do so is that our compatibility report demonstrated conclusively that there are no such impacts. Because there are no impacts, the county wasn't obligated at that point to impose any conditions on the emergency access road. And I think it's important that the record at this point has no evidence that there in fact would be any impacts to farm practices or result in increases to the cost of farm practices. The only evidence in the record as our ag compatibility report states, there are no impacts. And this is unrefuted expert testimony. And not only was the county entitled to rely on that, it's obligated to rely on expert testimony when it's provided, especially in the case here where there is no contrary evidence in the record. And again, because there are no identified impacts, the county was under no obligation to impose any clear and objective standards to minimize impacts, simply because there were none. And then I would like to turn to the condition number 1, unless you have any questions regarding conditions.
No, I don't. I was asking you, actually.
Okay, so with respect to, I meant conditions related to farm impacts. Sorry.
Oh, okay, no.
The final issue that I would like to address is condition number 1. And this condition precludes use
You have a
of,
slide with the condition so we can all see it?
Unfortunately, I don't have a slide with that condition. Ms. Fields, do you have a slide of that?
I was putting the staff decision on condition 1, and I can share that with you all. It is the Word document that was turned into a PDF for the decision. But bear with me as I share condition number 1.
Thank you, Ms. Fields. I just would like everyone to have a chance to see what we're talking about.
And it's the bold. It is the bold portion of the condition that we would like to discuss. And our read of this is that this precludes use both for facility-related construction, but also construction related to the access road itself. And that's a bit confusing to us because the use of that portion of tax lot 200 is necessary for the construction of the emergency access road itself. And on page 17 of the decision, staff goes into an analysis and essentially concludes that where you have a temporary construction easement, that use goes along with the emergency access road itself. And we view the construction related access for the emergency access road along to tax lot 200 as integral to constructing the emergency access road itself. Our testimony that I submitted yesterday, which I understand is not yet uploaded, discusses this in a bit more detail. But the point we're trying to make is that the use of that on a temporary basis, so during the construction only of the emergency access road, that is essential to that construction. It avoids out of direction travel. Absent that, we have one-way travel with trucks going on roads that they could easily just turn around. There's simply no space to turn around in the construction easement area other than that area. It also addresses a lot of comments that were raised by the public in relation to the school. By moving construction access to the west, that avoids conflicts at an already somewhat confusing intersection and addresses really the concerns related to the school. And for these reasons, we view this portion of the temporary construction easement the same as we view those portions that are immediately adjacent to it through the length of the road. And so what we are specifically asking the hearings officer is to modify this condition to be consistent with the reasoning set forth on page 17 of the staff decision. And again, that specifically recognizes that where use of the temporary construction easement is necessary for construction of the road, that is permitted as part of the utility facility necessary for public service. And so that is really the only modification that we're asking for with respect to the decision or the conditions.
Okay. And just to restate it, to tell you that I understood, or to make sure I understood, you're talking about what I refer to as the dogleg,
Correct.
the proposed temporary easement across tax lot 200, just for the purposes, the use of it for the purposes of constructing the emergency access road. We're not talking about hauling materials all the way down to the proposed facility site, correct?
That is absolutely correct.
Okay, and by facility, I'm separating emergency access from water treatment. I could say water treatment plant or proposed water treatment plant. I understand that in your view, as you've discussed it, the emergency access road is also a facility. But
yes, to be clear, the construction related to the water facility itself, north of the project to which the emergency access road leads, we do not intend to use the road for construction of that portion of the facility, correct?
Okay.
It's only for construction of the emergency access road located in Clackamas County.
And I heard you point out as in support of that it moves the access point onto Bluff Road, approximately, what is it, 300 feet further from the school, something like that?
It is about that distance, and it avoids construction related conflicts at that intersection.
And that intersection is I think a 4-way intersection plus the existing like access road. So, okay, I understand. Yep. I understand. Thank you, sir.
And with that really concludes our presentation. And obviously we're happy to answer any questions that you may have.
All right. And I think we'll get back to that with a question period. At this time, I'd like to invite the appellant to have an opportunity to present evidence, testimony and ask some questions if the appellant has questions of the people that we just heard from. Mr. Narrison, you're still muted.
Good morning, Mr. Cox.
Oh,
my name is Carrie Richter, and I'm a land use attorney at the law firm Bateman Seidel, and I represent Surface Nursery as well as the Cottrell CPO. I have some legal issues to cover, but before I get into that, I would like for Sean Narrison to provide some response initially to your question about the key for the fence and the location of the proposed emergency access way, because I don't think that the way the Water Bureau explained it was very clear. And so I'm going to let him do that first and talk a little bit about how he views what is proposed to exist, what we have in the record for materials, and then I'll follow him if that's okay with you.
That's perfect. Thank you, Ms. Richter.
Okay, we're talking about the emergency access road only, and we're not talking about a construction road. Is that?
Both, because this is a de novo. We're talking about the entire application and everything that was discussed here. I'll consider and make a decision based on concerning the application at the end.
Okay, so my name is Sean Narrison. I'm with Surface Nursery at 33740 Southeast Lusted Road, Gresham, Oregon. And we're opposing the construction road and the emergency access road. So in the Global Wise report on construction, he said that the water filtration plant will not cause any significant changes to us. And so when they have this emergency access road, we will not be able to use it. And I've talked to them before. They've offered it And I says, no, that's not an option. When Surface Nursery starts digging in the wintertime, we have a picture like a bulldozer, but it's a digger machine, and the cleats on that would destroy the road. And we have property that we lease on the east side that we have to constantly cross back and forth. And we would leave a foot of mud on that road at the end of the day. I mean, it's just impossible to use that road. So we have to build a road to the west of it at our expense. And anytime I consulted with a construction company that builds these type of roads, and I said, from the ground level, how much higher are they going to have to build it up, even if they go down subsoil? And he says, well, 2 to 12 inches. Well, that means we're going to have to build our own road just to the west of it. That's going to have to meet up to the same height. Otherwise, it'll just be a drainage problem. We'll have a mud hole. So, so we're losing more farmland by having to build our own road, and the expense of it. I can't imagine it being under $50,000, even if we did it our own. So we have this road that we will not be able, they have a road that we will not be able to use. And then they're taking eminent domain on part of our property at the north end. And if they think that doesn't interfere with the way we farm or financially, I don't know what does. You can't take away our farmland. So they're going through the eminent domain process of about 0.92 acres. Well, that's basically about 9,000 trees that we cannot raise anymore, even. And so then now we have to go to the west and build our own road, which needs to be 18 feet wide. We can't plant our first row of trees until it's 6 feet on the other side of that. And so we've lost 26 feet because they also want a 2-foot buffer, which I'm not understand why they need a 2-foot buffer on eminent domain land and our land. So we're just losing farmland at quite the rate. So
how many trees did you say?
Well, we grow about 10,000 per acre. We're a bare root nursery, so we're not a containerized nursery. And then when they talk about restoring dirt back to farmland, that's impossible in the bare root nursery. You'll never get your pH right. Everything will be wrong. Let alone the invasive weeds that'll be possibly brought in with like yellow nutsedge and things like that you can't control. So we never allow dirt from other land to be brought on to our farming because you can't compare it. So so if we were a container nursery, yeah, we could do that. We're a bare root nursery, so we have a very perishable product. So we're losing a lot of farmland. Basically 26 feet by 2,000 feet would be the road that we would have to build, that we just have to build a whole new road. Another expense is right in the middle, right during the road, right on the property line, we have an air vent for our irrigation system. So when we turn on our 75 horsepower pump and the 6-inch line that starts pushing it uphill to the county line, we have to have air vents for the air to go out, or you'll just start blowing fittings. Well, now we have to move that. And the expense of moving a 6-inch mainline air vent at least 30 feet, and now that'll be put in farmland. You can't put it in a road right now. So that's going to be another expense, is moving this airline. So there's another expense to us. Another thing that they failed to put in their report, Global Wise's report, is we lease the property right around the backside of Cottrell School. And we have to cross this emergency access road or construction road multiple times a day. Like today during the summer, we might cross it 10 times. I don't know how we're going to cross that with construction, especially, or emergency access. We need, because we have the right to farm, we need to be able to get to our fields. And this would prevent us from getting to that field without crossing this road. Another thing I wanted to bring up is on the original application, they said Debbie Surface signed as the application was going through. She did sign a document, but what she signed was a document that says the Portland Water Bureau is attempting to build a construction road on your property. Are you aware of it? She's, yes, I'm aware of it. She doesn't want it. So then they put it in the application. It's like, if you read the fine print, she was only acknowledging that they're going for the permit. And so we were misrepresented represented in that. So what she did is she put in another letter, I think you said it was June 17th, that withdrew her application, which
I saw that.
She never approved it anyway.
I saw both documents.
Yeah. So if you read the emails that were sent to me, you know, they just said, no, Debbie is not saying she approves this and everything. And then when the application came out, everybody just thought, my phone started ringing. It's like, why'd you approve it? And I said, we didn't, we were misrepresented. So to say that this will not have any impact to our farm practices is nothing but, I mean, it's exactly what it will do. Everything is time sensitive. It's a lot at stake for us that I'm not sure we'll be able to handle. I know we couldn't handle it. Carrie, did you have anything else you wanted me to add to that, or?
No, thank you. I think that's fine. I think I can take it from here, but I've lost you all here. So what I want to clarify for the hearings officer is that the gate that was referred to earlier, and Sean can clarify if I'm wrong, if I've got this wrong, but the gate that the hearings officer referenced to the solar facility may well be the location of the gate at Bluff Road, but the road that the Water Bureau is going to build goes over the surface property line to the west and into the area that is part of the existing farm road by 5 feet permanent easement, 10 feet, an additional 5 feet for temporary. So the statement that the Water Bureau made that the farm road adjacent to the solar facility will be able to stay is incorrect. It will have to move further to the east in order to exist.
I think, let me clarify, because I want to make sure I understand what you're saying. As I viewed the exhibit and the applicant's testimony about that exhibit, it's showing what we've all just discussed, that existing road, a farm road that will be, that the new road will cover, but it will jog over at a certain spot past that solar facility. That the contention here is that your client also uses portions of that farm road, but his use is different. He's using it with what I view as a tractor, but a tractor that he's saying will damage that gravel road, so he won't be able to use it on that gravel road if it's built. Was that what you're saying? So that will require him to build a new farm road for his own use adjacent to the completed emergency access road, assuming it were built on the road that he's using now.
Correct. And I would like to add to that, the Water Bureau testimony, Mr. Peters' testimony today was that the Water Bureau intends to share the road, right? So that surface will be able to, the implication is, drive north and south on this emergency access road freely. And as they do today, that is what supports the claim that there are no impacts. But I have submitted into the record copies of the temporary and the permanent easements that were provided to Mr. Narrison as part of the 40-day letter associated with the condemnation. And I will read.
I understood it slightly differently, Ms. Richter. So let's make sure that, you know, I understand what you're saying. I did not understand that that the Portland Water Bureau was suggesting that that Mr. Narrison could use the entire length of it. That he was saying that that key was held by the solar facility, and that they would have access to their solar generating facilities on that through that same gate. but I understood them to say that Mr. Narrison and Surface Nursery would continue to access the portion of the road that they can do now, not that they would be able to go through that gate. Is that what you understood?
What I was pointing out was Mr. Peters opened with a statement that that the Water Bureau's intent was to share the road together.
Yep.
And sharing the road together implies to me that the Water Bureau's road is going to go over the top of Surface's current road. So
Yep.
Surface either shares it together with the Water Bureau, or it builds its own next to the proposed road.
Mhm.
Those are the only two options.
Yep.
And what I wanted to point out in the easement documents that I've submitted into the record, they include provisions that say things like grantor, which is Surface, will keep the easement area open, accessible, and passable at all times. Grantor will erect no fence, gate, or other impediment to grantee's access within the easement area without prior written consent. That is not shared together. That is not unimpaired access. That is not Mr. Narrison's farm workers' bus parked on the access road while it unloads its workers. That is not a tractor pausing as it moves up the road. That is not unencumbered access without written consent. That is not open and free unencumbered access as Mr. Narrison's operation currently enjoys. I'd like to read from another section of that permanent easement. Grantee will construct and maintain a gravel all-weather surface road in the easement for mutual use of grantor and grantee. Now, if it stopped there, maybe, provided, however, that use by farm equipment is prohibited without the prior consent of the chief engineer of grantee. So the 10 times that Mr. Narrison drives his tractor across the road in order to get from tax lot 200, his farm on the west, to tax lot 200, his farm field that he leases on the east, he has to ask the chief engineer of the Water Bureau for written consent to go back and forth. That is not a customary farm practice. And that crossing has to happen regardless of whether or not Mr. Narrison builds a new farm road to the west. So not only has the Water Bureau essentially cut his farm operation in half, he has to get written consent in order to go back and forth. That would require a significant change to Mr. Narrison's farm operation, and something that the applicant did not discuss at all. I would like to direct the hearings officer's attention to pages 31 and 32 of the applicant's farm impact study analysis. That, I think, shows the best cross sections of what the Water Bureau believes will be constructed. And there is a wide portion on the surface property, which is the wide easement, 40 feet wide at the north side of the surface property. And then there's a narrow easement when the road jogs onto the solar farm or the solar property. So the greatest impact to the surface nursery is in what they call the wide easement. And the wide easement indicates that it shows a 40-foot easement to include the permanent easement, construction area, and road, and then a 12-foot temporary farm road. It says for construction. Now, it is not clear to me exactly whether that's for construction of the Water Bureau road or if it's a farm road for farm access. Like, this is the road that Mr. Narrison is going to build parallel in order to provide his farm access in the meantime. But either way, the loss of farmland associated with the 40-foot easement, coupled with this 12-foot farm road for construction is significant. It is in the order of magnitude, something that Mr. Narrison calculated over 2 acres. That's significantly larger than the 0.6 acres that the applicant indicated would be permanently lost by this proposal. Mr. Narrison indicated that it would cost $311,000. He would lose $311,000 approximately dollars per acre of
I
farm
didn't
product.
get a note of that. How much?
$311,663 for every acre of bare root nursery stock for every 3 years. So if this takes 5 years to build, that's 2 grow cycles in a temporary phase. And then, but most of this is permanent. The 40-foot easement is permanent. And whatever Mr. Narrison has to build in order to recover access to his property is on top of that. And those are both permanent. If you look at the bottom picture in the wide easement area or cross section on page 32 of the farm impact study, the Water Bureau is suggesting that this farm road will be outside the 40 feet at the time of construction, but then that farm road will move 8 feet to the north, giving Mr. Narrison back 8 feet of farmland. Now, why in the world would a farmer construct not just one farm road? He's going to have to construct 2 farm roads because he has to move his road 8 feet to the north in order to recover recover that additional 8 feet that was lost. I would direct you to the numerous save the dump cases where the Supreme Court said the mitigation cannot be imposed on the farmer. It cannot be imposed on the farmer even if the applicant will pay for it. In Stop the Dump, there was an issue with a pheasant farm, and the pheasants were afraid of would be scared by falcons that were used to kill seagulls. And the applicant in that case said, we'll build you a visual barrier so your pheasants won't see the falcons. And what the Court of Appeals said is you cannot impose that mitigation on the farm practices. And what the Water Bureau here is asking, they're asking Mr. Narrison to get written consent to use their road. They're asking Mr. Narrison to give up land to accommodate the road, losing farm products, increasing their own cost, and then build their own road. These are all changes to farm practices that have significant impacts. And the applicant didn't even doesn't discuss any of this. They say, we're giving you back 8 feet. You're going to lose 0.6 acres. No harm, no foul. That is insufficient to meet the farm impacts test. I submitted into the record a video that shows this area, and I just so you can get a visual of the farm impacts. And if I can share my screen, if you will allow me to share my screen, it's a 1-minute video.
Yes. Let's have a look. We can do 1 minute. If it works. Technology is what it is.
No, I know. And it was taken in dusk, so it's a little dark. Can you see that?
Post all the way to here,
I don't see anything.
White pieces of tape is 40 feet. Then
okay,
all the way.
It's not. I've submitted it into the record, and we'll leave it at that. I don't want to take any more of your time.
Let's do that.
Sorry about that.
I will view it, and I will
farmland
consider it. let's go ahead
that
and
would be
stop.
taken up from
What
the
it
easement plus,
shows is that
the farm.
it shows the 40-foot easement area, and then it also shows the additional 20 feet that will be necessary for Mr. Narrison to build his own road. And it shows you the rows of bare root crops that will be impacted. So I want to move on beyond the significant impact piece of this and talk for a minute about the other issues raised in the appeal. And the first one deals with the construction impacts. The applicant does not evaluate the construction impacts associated with the emergency access road. And as Ms. Fields explained, the reason why they didn't is relying on a case called Citizens Against LNG versus Coos County. And in that case, LUBA considered whether or not a natural gas pipeline on land zoned for forest uses had to consider construction of that pipeline. And what LUBA said was these pipelines are allowed in forest zones, and the condemnation statutes allow for the taking of land to install these pipelines. And the question in that case is important, because the question is whether you have to consider construction as a separate use, And the appellants are not asserting that the construction of this access easement has to be separately considered. What the appellants are arguing is that under the farm impact test, you have to consider cumulative impacts. And this was discussed in the Stop the Dump case, but it was originally brought up in a case called Von Lubken versus Hood River County. And I provided the hearings officer with the case citation. But in that case, the construction of a golf course didn't consider the impacts associated with the construction itself. And what LUBA said is you have to consider the totality of the impacts. And then in another case that I've cited, Oregon Department of Fish and Wildlife versus Lake County, LUBA found that the failure to adopt findings explaining how shrub removal during construction would displace rodents onto farmland was error, even though that relocation might be temporary and might be the result of construction. So you have to consider from, the very start of the impact until, the end of the use as the window for consideration. And what the applicants failed to explain anywhere is how long it's going to take to acquire the necessary easement rights, how long it's going to take to construct this road. The application says 5 years. That's what they said. But that was when they assumed it was going to be for construction of the facility. Is it going to be 5 years, or is it going to be something less than that? How will, when they start construction and when they end construction, impact Surface's ability to farm? When they start construction, Surface can't use that road. So Surface has to have the adjacent road built, or they can't farm at all. The loss then is, the entire properties. So how the timing is going to impact Surface's operation is critical. The applicant has offered inconsistent statements of how much farmland will be removed. I talked about that, but there's no discussion about how construction will occur. What machinery will they use? How much dust will it generate? There is a blueberry farm right on the other side of tax lot 200. How much dust are they going to generate? They say none, because only the operations are relevant. That's not what the legal standard requires. The applicant submitted a construction traffic impact analysis. That construction impact analysis was completed for the purpose of evaluating the facility and the pipeline impacts to farmland. It talks about the Bluff Road connection as Surface Access B or Site Plan B, but it does not talk about how construction traffic is going to construct access B. And that's what's relevant. How many trips is that construction going to take? And where are those trips going to come from? So that's why the construction is really important, and that's why the applicant has failed to address that issue. Finally, I want to talk a little bit about the reasonable alternative piece that the applicant spent a fair amount of time on. And as the applicant noted, that they have an obligation to show that reasonable alternatives have been considered. The reasonable alternative that the applicant considered early on and didn't disclose as part of its presentation would be locating the facility on Powell Butte inside the city limits. And I submitted evidence of a technical memorandum completed by the Water Bureau where that alternative was evaluated. And I think if you look at the 3 or so pages of the excerpt from that memorandum, you will see that none of the reasons for why that alternative was rejected are listed as making that site unsuitable under 660-033-0130-16A. In other words, that memorandum says that the Powell Butte location provides technical engineering and engineering feasibility. It says that the site is big enough. It says that it can be accomplished. It says that there is nothing in terms of ownership or natural resources or wetlands that would preclude locating the facility there. And if the facility is located on Powell Butte, there's no reason for a pipeline on emergency access road on EFU land. And that is an alternative that the county has to consider. The other thing, the CPO did submit some testimony today explaining why the Dodge Park access offers a legitimate alternative. The testimony was that alternative was rejected because of the steep slopes and the seismic concerns. But the testimony we've provided indicates that grading those slopes would eliminate the seismic concerns, and that is an alternative that was not legitimately considered. Finally, I would like to point out a couple of things about the conditions of approval that staff has recommended. I think you asked the applicant whether they were happy with the conditions, and if the hearings officer does decide to approve this application, the appellants request some revisions to the conditions. And I will leave some of those, the specific wordsmithing to the hearings officer. But the one I want to talk about specifically is condition 3. And it, as proposed by staff, it says construction.
Just a moment, let's, Ms. Fields, are you able to put condition 3 up again so we can see this? I mean, I have a copy right here, but not all the participants and members of the audience have this available.
Sure. Okay, so condition 3 says construction activities shall not commence until the water filtration plant in Multnomah County receives final land use approval. And the appellants would point out that this emergency access road is accessory to the facility. It cannot operate until the facility is in construction and moving forward. Right now, the Multnomah County review is in process and has not been completed and will not, it is unlikely to, and the hearings officer is unlikely to issue, the record in that case won't close until September 21st. And a decision will not be issued until sometime, I'm speculating, October. And
then there's perhaps an appeal period.
Right.
And perhaps an appeal.
And that appeal could result in a reversal or a remand. And what my client is concerned about is the emergency access road construction getting out ahead of the facility approval. And I think that the hearings officer has to make a finding that these conditions are clear and objective and will ensure compliance with the standards. And what I don't want is an emergency access road built out there that doesn't have a facility to go to.
Nobody really wants that. I see the point. Regardless of whether I approve the emergency access road or not, I can modify this to state receives final until
What if I could suggest, receives final land use approval that is beyond any further appeal.
and the appeal period has ended. So maybe I'll change that a little bit, but something to that nature. Mr. Holtberg, would you like to make a comment about that?
With respect to the condition?
Yes. She's asking that I modify condition number 3 in the event that if I were to approve the application, to state it like that, and the appeal period has ended. Construction of we're talking about the construction of the emergency access road.
Yeah, understood. Can I think about that for a few moments and then during our rebuttal respond to that issue?
Certainly.
Thank you very much.
Ms. Richter.
Secondly, I'd like to propose adding an additional condition. The application includes inconsistent statements about the use of this road. In some places, it says that the road will be used for maintenance of the facility when access is blocked. Sometimes it says it will be used for emergency access only. It says that the road will be driven once a month in order to evaluate its condition. And what's important is the traffic impact analysis submitted with the application and the farm impact analysis was very specific in capping its impact analysis to 20 trips per year. And it is the appellant's position that if the farm impact analysis and the traffic impact analysis assume no more than 20 emergency trips per year, this decision needs to be clearly conditioned to say that this approval authorizes use of this road for emergency access only in cases where Carpenter Lane access is not available and shall be restricted to no more than 20 trips per year. If the applicant intends to use it when their trucks are otherwise blocking Carpenter and they need to get a worker through, that is not emergency access. If they plan to use the loosey-goosey nature of this is when it impacts farmland and farm practices cannot be allowed to remain. And so that is why I urge the adoption of a condition that is very clear and objective about exactly what extent the Water Bureau can use this road.
I see your point. I'm a little hesitant on limiting it to 20 trips per year because I just can't anticipate the type of emergency. For example, a significant mudslide. I'm familiar with significant things happening, a significant fire, things that can be more than that. And if you combine a couple of disasters, you can get past 20 days.
I understand that, but if that's really what they are planning for, then their traffic impact analysis and farm impact analysis should assume, you know, a significant seismic event that requires 50 trips a day for 8 days in a row, 14 days in a row. You know, I mean, that the farmer has to be able to weigh in on the degree to which use of the non-farm use will impact their operation. And if conditions are going to be imposed to mitigate those impacts, they have to be clear and objective.
Okay. Something more to the point then would be emergency access by emergency equipment limited to when Carpenter Road is not available at the PWB facility entrance. Something like that. Not available. Meaning Carpenter Road is closed for an emergency. That's really what we're talking about. If the Gresham Fire Department can't get through Carpenter Road to enter the main entrance to this facility, they need their fire emergency access. Now, that doesn't completely answer your issue of it doesn't limit it to 20 trips, but I think the intent is to limit it to an actual fire apparatus type of emergency equipment. Isn't that correct?
That is part of it.
I know it's only part. And again, Mr. Holtberg, if you'd consider this for a few moments while we continue.
Absolutely.
Well, that largely concludes my presentation. I'd be happy to answer any questions. I understand that Mr. Holtberg did submit written testimony and I haven't seen it. So I would ask that you leave the record open for some period of time to allow the appellants to review that testimony and respond.
Well, let's just talk about it right now since you brought it up and we're into this hearing. So there's a request to keep the record open. I'll keep it open for a minimum of 7 days for submission of that additional material. And Mr. Holtberg, do you also request an additional period for a rebuttal period?
Yes, and you're going to.
Does any party or the member of the audience want an opportunity to provide additional evidence, arguments, or testimony? And I understand, does the applicant wish to waive the period for final written argument as part of my script? But what I'm suggesting is this. The appellant has asked for a minimum of 1 week. So 1 week for everyone to submit additional written testimony and evidence into the record, followed by a second week for the parties and anyone else who cares to submit a rebuttal to that evidence. And that rebuttal may include counter evidence, okay? A third week only for the applicant to submit a last word on this.
Here's Officer Cox.
Yes, sir.
Based on the issues raised today, I think we're going to need some substantially longer periods of time. We'll need to rebut the testimony and evidence given today with our own expert testimony. I would recommend that we do a 30, 30, and 14 or 30, 30, and 15 instead of the week, and week. I just don't think there's sufficient time, and I would rather not have to ask for the record to be left open during the process.
Those were minimum, sir. Ms. Richter, do you have a comment about the applicant's request for an extended open record period?
No, but I would appreciate it if you or staff would give me some firm dates on that before the end of the hearing so that the public knows exactly what, I mean, I understand I can count 30 days, but sometimes whether you count the day that you're starting on or you count from the next day gets confusing. The
Let's
more
just do
you
it
think
right.
about it, the more confused you get.
Hearings Officer Cox, I have just received word from my client that we want to reconsider the dates. Those may be too long. So they'll be longer than a week, shorter than 30, and I will get a final number or final numbers for you during our rebuttal.
Okay, then we'll postpone further discussion on a timeline for an open record period. Ms.
Thank you.
Richter, did you have anything additional?
Not if you have no questions. Thank you very much for your time.
And the materials that you submitted into the record, including what you showed me today, or the video that you didn't show me, and those things, as long as they make it to the county, and there is an open record, but I'd appreciate it if you could get them in by 4 o'clock today. I like to get my hearing materials and have a chance to review them. But
yes, I apologize. They went in at 9 o'clock this morning.
yeah, don't worry about it. We all face the same technology issues. It's great when it works. It's disappointing when things go south. At this time, I'd like to provide an opportunity for the applicant to provide rebuttal.
Hearings Officer Cox,
Yes, sir.
I believe that there's also going to be public testimony.
Yeah, there is, and I can handle it one of two ways. First, by splitting the rebuttal period, which is what my preference is, but I can certainly provide that opportunity for members of the general public. Then they won't have an opportunity to comment on what they hear fully. But I can do that if that's. I just think it's more efficient, in my view, to have you address the appellant and Ms. Richter first, but I can certainly provide that general public, and then you would have you would need to rebut anything that you wanted to or answer that during that period altogether.
Yeah, that would be, I think, our preference. As I said, we also have a large group of people, and we will be asking prior to rebuttal for at least a 5 to 10 minute recess so we can discuss rebuttal issues and then confirm the open record period.
Okay, and I have that shortly after 11:30. So let's. How many members of the general public are waiting to provide testimony and comments?
I don't have any hands raised.
Oh, let me make this clear. At this time, I'd like to provide an opportunity for members of the general public to provide comments or testimony in support or in opposition to approval of this application for the emergency access road. Please use the raise hand feature. Okay, none. Then, Mr. Holtberg, we're back to rebuttal by applicant. Do you want to ask for a recess at this time and come back on that?
Yes, if we could have 10 minutes, that would be wonderful. We can gather our thoughts and then get back to you with an open record period.
Okay. Not an open record period. A discussion of the open record.
Discussion of
yes.
Yes, and our response to the open record request.
All right, let's take a 10-minute break, and that gets us to 11:45.
Great, thank you very much. Appreciate it.